This was a difficult case. The defendant violated her probation by failing to comply with CPS directives. Eventually, CPS removed the children.
Boyfriend, who had been accused, was living in the same house with the little girl.
Deep down, I hate Dwayne, but I wanted a shower.
I ordered 90 days. It was a gift to not order the other 82. They're in foster care. Whether you go to jail or not doesn't make a consequence as to what happens to them because they're safe.
Before I go into the video, as you might have already guessed, this case relates to a subject that is sensitive for some people, but it's definitely tangent to that subject. The instant matter is about the little girl's mother continuing to allow contact and live with her monster boyfriend. This hearing is on the edge of what I will feature, and I have cut out portions of the arguments to keep it in line with what I'm comfortable releasing. That said, we already have a good idea what's going on here. There's absolutely no excuse for any parent who puts his or her children in harm's way like she did, but they're safe now, having been placed in a foster home, and now she has an 82-day stretch to serve. I wish it were longer, and so does Judge Middleton. Let's roll, nerds.
All right. Good morning, Ms. Gilbert.
Hi.
I'm going to go on the live here on the record. We're on the live feed, and we're scheduled for a probation violation hearing in the matter of Cassandra Louise Gilbert. The file number is 231968FY. The original charge was felony child abuse in the third degree. It was reduced to child abuse in the fourth degree, and the defendant entered a plea to that charge in December of 2023. So this matter's more than a year old. The conduct alleged is even older than that, but the plea was entered in December of 2023. Ms. Gilbert is here with her lawyer, Lori Hines. Also present is Assistant Prosecuting Attorney Gary Gabry, who is handling this case for the Prosecuting Attorney's Office, and Probation Officer Matthew Huff. And this has been a very difficult case for him. To recap a little bit, as I indicated, this matter was charged as a felony and it was reduced to a child abuse in the fourth degree. It was related to a criminal sexual conduct case involving Dwayne Shook. There was a preliminary examination that was held here in this courtroom. Mr. Shook was bound over to the circuit court. This all precedes Ms. Davis' tenure as prosecutor and Mr. Gabry's return. This was under the previous prosecutor administration. The case of Mr. Shook was set for trial, and as I understand it, I looked at the circuit court notes, the matter was ultimately dismissed by the prosecuting attorney. The defendant pled to this charge, and she was placed on probation. This was a difficult case, and Matthew Huff prepared a pre-sentence report. So he really did a deep dive into the facts of this case, and he was just as frustrated as I was trying to figure out what the correct solution to this circumstance was. So I did the sentence just before Christmas in 2023. I put the defendant on probation for 24 months. She was sentenced to 90 days jail, credit 8, and 82 days were deferred for her participation and cooperation with the probation. She had 0 fines. She had restitution to pay in another case, 22907 SM, which I believe was an embezzlement case. Yes, embezzlement under 200. She pled on the same day. I gave her 8 days credit, 8 days, and ordered restitution. So I made the restitution in the embezzlement case part of the probation in this case. But the most important condition was mental health and substance abuse treatment as directed. Cooperate with truthful testimony in the case of Dwayne Shook, which ultimately was dismissed, and most importantly, cooperate with Children's Protective Services, follow all of their directives, and sign a release. To further muddy the waters, the defendant was also charged with a criminal offense of truancy while this case was pending, and having another criminal charge could also be a violation of her probation. The truancy case that is still pending, the defendant pled not guilty. That is pending a final pretrial, I think, in April 3rd. So that is in file number 242170SM. I printed all this stuff out so I wouldn't have to switch between screens in the on base. So there was a petition filed, a probation violation petition filed by Matthew Huff. It was amended. The original petition was failed to report on a monthly basis. That's been withdrawn. So the current status of the probation violation allegations is she failed to cooperate with Child Protective Services directives. She failed to abstain from the use of alcohol or drugs or test on demand. The primary concern was the allegation that the defendant failed to comply with Children's Protective Services directives. The allegation in the status report is that even though she was prohibited from allowing the children to have contact with Dwayne Shook, they were in constant contact with him, including the child that was the complainant in the criminal sexual conduct case. This petition was filed a long time ago, and this matter was set for hearing several times. It was adjourned, I don't know, 3 times because the defendant would always end up in the hospital either the day before or the day we were supposed to have the hearing. So we are here today on the allegation that the defendant violated her probation by failing to comply with CPS directives, specifically allowing Dwayne Shook to be in contact with her children. And then the other allegation that she failed to test or continue to use a controlled substance. Having said all that, Ms. Hines has been in contact with her client. She's had a long relationship with her. These have been set for several hearings, as I indicated. Ms. Hines, it's my understanding from what you said earlier, the defendant is going to admit to the violation.
She is confused on Article 3, failing to report on a monthly basis, and I never really.
That one's dismissed.
Oh, it was dismissed.
Yes.
I'm looking at an amended one because now I'm looking at Article 10 and Article 11. So that's the one she's confused on.
Early on, she was kind of off the grid, but since then, she and Matt have been in contact.
And that was my understanding from meeting with my client. So, but it was still on the amended petition. So, with that, yes, she will agree and enter admission to failing to cooperate with CPS directives and enter admission to failing to abstain from the use of alcohol, drugs, or submit to a test on demand.
Is that true, Ms. Gilbert?
Yes.
All right. When this all went down, there was a criminal sexual conduct charge against Dwayne and a child abuse 3rd degree charge against you. This would have been in December or late last or fall or early winter of 2023. Were you under the supervision of St. Joseph County Children's Protective Services?
Can you say that again?
Were you under the supervision of Children's Protective Services here from St. Joseph County?
In 2023?
Yes.
Yes.
And was there in fact an open case in the family court, abuse neglect division? There was not an open case?
No, there is now, but not then.
Yeah, there wasn't.
All right, there wasn't then.
Because I called and they told me I didn't have an open case.
All
But
right.
you had them involved in the left. Is that right?
All right, but then at some point, there was an open case in front of Judge Tomlinson and now
No, just recently, they've just opened a case,
All right.
this 2025
Oh, in front of Judge
King.
Kane.
Mhm.
All right. I remember talking to Tom Robertson about this. All right. And
And on November 18th of 2024.
Yeah, it might
There
have
was a
been,
hearing and the children were removed because of contact
Was it
between the child
24?
and the
Okay.
perpetrator.
okay.
I became involved in 25. She had Luke Knopfsinger originally, and then they appointed me as
All
her
right.
neglect and abuse attorney.
So because of the fact that you allowed to have Dwayne have contact with the children, were the children removed from your custody and placed in foster care?
Yes,
And they're in foster care now.
Mhm.
Is that a yes?
yes,
Okay.
sorry.
And so that violated this condition of probation that you were supposed to cooperate with Children's Protective Services. All right, have you relapsed? Are you using again?
Oh, no,
All right, so it wasn't
I've
so
been
much.
doing my drug test. It was one time.
All right, you used or you missed a test?
I took one tramadol
Okay,
and it was one time at the beginning. And I've been passing ever since. Besides, I was on marijuana a couple times, but I am now clean. I don't even smoke marijuana.
where are you living?
I'm living in Sturgis right now.
Where is Dwayne living?
He's in jail.
LaGrange County.
Oh, I didn't know.
No, he's in Elkhart County now.
Oh, he was in LaGrange.
In which county?
He's in
Elkhart?
Elkhart County now.
I wasn't aware of that, but he has no charges pending in St. Joe County, Michigan. Is that correct?
Not right now, Your Honor.
All right.
He should though.
All right, you've acknowledged that you allowed him to have contact with the children in violation of the directive. In fact, to the extent that they removed the children, it took a long time, almost a year for that to happen. All right, I accept your admission to the violation of these two conditions of probation. Your admission to the use of marijuana and tramadol is not very compelling because you got back on track. Your more recent tests have all been negative.
Yeah,
The concern always was allowing Mr. Shook to continue to have contact with these kids. And a private citizen, I didn't even have the case, came to see me and they were, I guess I'll say, outraged by the fact that nothing was happening with this case. And I didn't even know what was what. But eventually CPS removed the children. All right, so the question now becomes, what do we do? I ordered 90 days in jail and deferred 82 days. And this probation was pretty much a failure, at least for the primary purpose of protecting the children. And I'm embarrassed about it. All the way from December of 23 to March of 25.
no,
Well, no, I mean, that's how long this case has been
I was gonna
open.
say, because I lived with my
And my
kid's
order
dad.
wasn't very successful. So, Mr. Gabriel, what's the people's position here?
Well, Your Honor, I think I think I can sum it up from what I've been looking into this whole matter and attempting to understand how it got to where it is. And I think the most disappointing things is that when the mother of a little girl is put in front of a tribunal and admits guilt, like she did in this case, which was a plea bargain. I mean, the prosecutor at that time, Prosecutor Marvin's office, this was originally a 10-year felony, and here we are in district court. And when that kind of, I guess, approach from the prosecutor, a willingness to give her some leeway, is met with a probationary period, and then we find out that she's still not taking this seriously, that she still doesn't understand that her little girl was being by her boyfriend, then allow that boyfriend and that little girl to be in the same house up until, like, my notes going through this, and in fairness to CPS, this is just information that came to us. I don't have any reports from them after October of 2023. But in November 18th, they had to act, and there was an emergency hearing, because guess what? The boyfriend, who had been accused, was living in the same house with the little girl. I mean, how a mother can let her little girl have to go through that again is beyond me. So, you know, I understand there's all these other issues, and we deal with finances, and I think she actually wrote a letter to Prosecutor Davis explaining that, gee, I didn't have any place else to live. So when Dwayne's mother said I could live in her house, Dwayne was already there. So I brought the kids in, but
No,
he
he
was in the
wasn't there when I
basement.
first went there.
We'll have you.
So I've got this information, and now here we are. I mean, I think the court ought to use all the time it has left to just try to impress upon her, and then we'll know where she is when I get done with what I think we ought to do, and that's act on this case again. It was dismissed without prejudice. I believe I'll have the cooperation of White Pigeon Police, cooperation of DHS, and we just need to re-interview some people. And one of the witnesses is going to be Miss Gilbert, based on her plea agreement. So I think she ought to be put in jail for the remainder of whatever she has left on the year to serve.
Ms. Hines, what would you like me to know?
Cassandra has been, she has health issues, Your Honor. She just was diagnosed with second stage ovarian cancer. She has been meeting with Matt and keeping in contact with him. She is cooperating with her DHS case. She entered an admission there, so services are being, you're doing all services. She's attending Pivotal. She's changed her mental health meds. She's on some new heart meds. And I don't see what jail's gonna do. The children are out of the home. I understand you gotta penalize her. But she's got a lot going on, and she is cooperating, and she is trying. She is here today. She made an admission. She cooperates with me. She keeps me up to date on what's going on. And I think she's also doing that with Matt right now. So, you know, Matt and I have emailed with each other. I explained our position as well. We're asking that she be allowed to continue probation and not be imposed jail time. Thanks, Sean.
Thank you. Ms. Gilbert, what do you want to tell me?
Just that, like, I made a mistake. Like, I mean, I called the court. I asked myself, when Dwayne's mom asked me if I would take over payments because they were moving to South Carolina, and they said, yeah, it was dropped. I didn't know at that time that CPS was a civil. I got it mixed up, and they had their own case. I had to get out of Joseph's. My kids are the ones that begged me because they didn't have no water at their dad's. And when CPS came, I was literally only there like 2 months when I left Joseph's. And when I first went there, Dwayne was not there. His mom can verify that. Everybody can verify that. Then, of course, what do you know? I didn't even honestly, I honestly, deep down, I hate Dwayne. But I wanted a shower. I needed a shower. My kids got excited because they were going to have their own room. they begged me, and they wanted out of their dads. I mean, it was not livable. Floor was falling through. And at the time I called Keystone and they didn't have any open beds for me and my 4 kids. I was excited. My kids were excited. Finally, a own house. And Dwayne wasn't there at the time. But of course, like a couple weeks after we were there, his mom let him come back there. But since then, actually, matter of fact, he's called me several times from the jail. I had to call and have the jail number blocked, which means my brother's in there and I can't talk to him, but I blocked that. Like, I'm doing all the right things now. Like today, I literally just got out of the hospital, just got put on heart meds, and I still rushed here
Well, I'm glad you were here.
and make it to court. I called him, I told him I was coming. I just left the hospital
And I appreciate that.
and I had a doctor's note but I'm on my way. And I was staying in a house and they were smoking weed. My sister-in-law's, which is my kids' dad's sister, and I couldn't even be in there because I couldn't even handle the smell. Like, I don't smoke weed no more. I don't do a lot of things. So probation has actually helped me. Also, I think I told Matt this. Matt was proud of me, but I was with a friend who just recently, a couple weeks ago, 3 weeks ago, I think it was, who actually tried stealing something and handed me the cart. What did I do? I did the right thing. I said, oh no, I lost a friend of it, but I took that cart right back and told him, and of course she ran out of the store.
Well, that's not a true friend, so
I
good
know.
for you.
But she was a good friend from school and we just got back in contact, but I know what she tried doing at that time. Luckily, she had it wrapped up with the bag of, she had her pop bottles in, and I could see that there was something sticking out. And I'm like, what is that? So I lifted up it and I seen she had like hair stuff and nails and I think pop under there. And I'm doing my mental health. Actually, I have an appointment today, actually, at 1, to the med clinic. And got back on my seizure medicine also. That I haven't been wanting to take also because of the way it made me feel. But I'm trying.
All right.
And probation has helped me.
I think we've made some progress. We did not do well by these children.
And I'm admitting to that. I guess I should have did things differently. I should have maybe, I had to get out of Joseph's. That was one thing, the one CPS said. So I had to get out.
Well, I'm not clear on the time frame of this because the person that came to see me, it was in the last summer, and they were outraged. There'd been some sort of a hearing that Dwayne was in continuous contact with the children, and nothing had happened from CPS. And I had no clue about any of this, so I talked to Mr. Robertson, who was the hearing officer at that time. And I would say this would have been like last June or July, maybe. And the probate court was involved in it. Apparently it took all the way from that till November before they removed the children. The other concern is while you're on this probation, the children were going to school. One of the kids missed 106 days of school in the White Pigeon School District, and that resulted in the filing of the truancy case. So we were doing a very ineffective job of trying to protect these kids through this probation. Mr. Huff, you drew this difficult assignment and you spent a lot of time on this case. The defendant has acknowledged the violation of failing to follow the CPS directives. What's your recommendation?
Well, I have a couple of points that I'd like to talk about because I think it's going to affect potentially the recommendation that I would submit to the court. I'm not entirely clear to what degree or to what fashion Ms. Gilbert's admitting to this probation violation. Obviously, she's admitted that she's violated Department of Human Health Services directive to keep her daughter away from Dwayne. But there are also a concerning amount of missed drug screens that I've been alerted to. The most recent drug and alcohol testing record from the Day Reporting Center was gathered this morning. She failed to test yesterday. She failed to test on the 20th. She failed to test on the 18th, the 11th, the 10th, the 7th, and the 4th of March. That's just this month. She's making testing between them as well.
Now, who would be paying for the testing? CPS?
I don't know the funding source. She is in treatment at Pivotal, so there's potential for some testing reimbursement there.
It would be requirements to her neglect and abuse case. So Department of Health and Human Services would be paying for this testing.
All right. Go ahead.
So I wouldn't be doing any due service to not bring that to the attention. I was not aware of these. There was a situation in which the Day Reporting Center had to have a specific information release signed by Cassandra in order to release to me the testing records. I had talked to Cassandra before.
That's because these were not our tests, they were CPS tests.
So when I had asked the reporting center how she was doing, there was no release of information signed on their behalf. Now, when I talked to Cassandra said that she had signed one. There must have been some sort of confusion. I cleared that up in February after some prompting, got access to her testing record, and this is what I'm seeing now. So I think it's important that, because I don't know, and maybe it is on the record, how she addresses those violation of Article 10 probation violations, but that's particularly important. And I'd like to get a little bit more insight into what her side might have to say about that before I put forth a recommendation.
I don't need it.
Okay.
The primary issue is the other issue. She admitted smoking marijuana. Sometimes one tramadol doesn't bother me, but some of the tests in between were negative. Her life is so dysfunctional that it's hard for her to dot all the I's and cross all the T's.
I would just say that the reason I brought that to attention is because of the statute, which dictates the capacity of how much jail the court has to use per probation violation in which she's found guilty. And so if she's not admitting guilt to those probation violations, then my recommendation would be altered as a violation of Article 11, and failing to comply with DHS would only permit up to 5 days in jail as a consequence. If the court's going to move in that direction, then it could potentially, I suppose, handcuff what you're considering. I also would like to know more because I'm not exactly clear on what Cassandra was admitting to, because our conversations in the past, me and Cassandra's that is, included her statement stating that she wasn't bringing the kids around Dwayne and that she had evidence to prove that she wasn't doing some of the things that I had heard that were alleged against her. So I'm not entirely clear exactly what it is that she's admitting to, that she's just generically, she had brought them around. To what degree, how many times was she living there? How long was Dwayne there? Those sorts of things are important, I think, for the court to establish before, because if this is just one time she goes in for a shower and the kids are there for 2 hours and then they leave, that's one thing. If she's been living there with Dwayne and the kids, in particular Cara, are there for 2 months.
That was my understanding.
Then my recommendation would be different in that circumstance as well. So I don't want to just fire from the hip here and make a loose recommendation.
Well, you make several good points. We were prepared to have a hearing and she made admissions. Now, this is a probation, but it was a probation with a deferred sentence. She was told that if you don't comply with this probation, there's 82 days hung over your head. Mr. Gabriel's asking for 365 days minus 8. There are some restrictions on what the court is alleged to be able to do in a probation violation hearing unless good cause is shown. Couple issues. This is a deferral. So I had held 82 days in advance. The original sentence was 90 days. Good cause shown. The defendant was charged with a larceny in file 222574. She stole some cash from a woman named Elisa Lentz in Three Rivers, and that matter was dismissed as part of a plea in the embezzlement case, which was 221907. I gave her 8 days jail credit, 8 days, and she was supposed to pay the restitution for the embezzlement as part of her probation. In this case,
I've been paying.
she doesn't have any money, and so very little, if anything, was paid toward that restitution.
I just did a payment plan.
All right, I know. So there was the first larceny, then there was the embezzlement. The larceny was dismissed for a plea to the embezzlement. That restitution was included with the embezzlement. The embezzlement, I gave her 8 days and made the restitution part of this. So there's that. In the meantime, while she was on our supervision, she got charged with, actually it preceded it, the criminal charge of truancy. She was on bond, was in 242170. That allegedly occurred up through November of 2024, was authorized by the prosecutor on February 5th of 2024, excuse me, December 5th of 2024. So she was on our probation at the time. She was failing to send the children to school for 106 days. And so that wasn't good. And as I indicated, people had said through the summer that she was having contact with Dwayne, and that was apparently some of the testimony that was taken in court in Three Rivers. We had a disconnect between probation and CPS. We didn't have clear releases. We weren't getting information. I don't know that even the prosecutor was getting the information. But then there was a admission in November. And as I said, this case took several months to get here because it was adjourned several times. In addition, the prelim in the CSC case was very unpleasant. The child was called to testify. Dwayne was sitting where you're sitting. His father got
irate,
disruptive, and I put him in jail for contempt. In the meantime, the child is here watching all that. So the matter's bound over to circuit court for a trial. It gets bumped down the road a couple times, and then finally the prosecutor just dismisses it. Again, before Mr. Gabriel and Ms. Davis got here, but my understanding was that the child wasn't in a position to cooperate and testify because things were not well supervised. So good cause. I deferred the 82 days. I ordered 90 days. It was a gift to not order the other 82. A larceny was dismissed and embezzlement was rolled into this. You didn't pay restitution on the embezzlement. You got charged with truancy while this case was pending, you have not been convicted of that charge. You pled not guilty, and it's set for
Later hearing.
a hearing on the 3rd of April.
Oh, I haven't even got
But
it
the
yet.
allegation is that the children missed hundreds of days of school. And you can't go back and do that. And the child who was traumatized by your boyfriend and had to testify in front of him in court and have her grandpa yell at her, or his dad yell at her, you moved back into the same house with them. To the extent that CPS took your parental custody rights right now, and the children are in foster care. One of the reasons for the deferred sentence was it would have left your children homeless. At that point, you had custody of the children. CPS hadn't filed any petition to remove them. And Mr. Huff had a concern that A, you might lose your benefits, and C, the children would just be unplaced. Well, now they've been placed. They're in foster care. And whether you go to jail or not doesn't make a consequence as to what happens to them, because they're safe and secure right now. And the case apparently is now being supervised by Children Protective Services, and there is an open case in the family court. The testing issues, as Mr. Huff referenced, are kind of secondary.
I do want to say.
But I do want to clarify one thing. The children had been living in the same home with Dwayne for a couple of months before CPS came in and removed them. Is that correct?
It was actually when Dwayne moved back in the house. I was living there for 2 months. When Dwayne moved back in the house, it was like 5 weeks, 4 or 5 weeks. But this time I was like, I was on Kara's shoes, and she was back and forth between my house until CPS said that the kids could not be at their dad's again. From Josh Green, he said that they weren't allowed to go back there again. So I had no choice.
Now, the children's dad is a different person, correct?
Yeah, he's out here.
What's his name?
Joe Wober.
Okay.
The kids pretty much lived with him, pretty much. Yeah, I had custody, but I was bouncing around. And the truancy, just because I had full custody, it fell on me. But it was him because Mikey didn't want to go to school. He made up different excuses. But
Yeah, don't speak to that because it does go to your pending case.
Okay, I didn't know. Sorry.
Well, that's I'm not unwilling to hear it, but I just want to protect.
I've been
your concerns.
cooperating. Like the foster worker wanted me to get a job. I did that. I've been I work now. I doing pivotal. I'm doing everything I'm supposed to do.
All right. Does anybody wish to give any input from Children Protective Services? You're here as witnesses. I didn't know if anybody wanted to offer anything or just be here to see what transpired.
Our current foster care worker isn't here, so I'm going to object to any testimony by CPS or DHS.
All right, fair enough. Thank you.
And the testing, I didn't know they were supposed to call me. They've always called me until the last few weeks. I just told my foster worker that yesterday. She was supposed to check into it. I said I have proof on my phone that they have not been calling me. I called them last week to test myself. And my foster worker was supposed to check into it because I talked to her about it yesterday and asked why they weren't calling me to test.
Okay.
Your Honor, I would like to indicate that it's our understanding, and obviously Ms. Hines might know this, that at least at this point in time, the Department of Human Services has not approved visitation between Ms. Gilbert and children. So that is, I think, of a concern, given the fact that this has happened in November. And here we are in March, and they still haven't been able to work to the point where she can have some kind of visitation.
She was initially having visits with the children, so that's not
why
necessarily a
have they
correct
stopped?
assessment. And it has to do with the DHS case, not
Well,
the
it
kids.
does. And this case was adjourned, as I said,
It was 'cause kids
multiple
started
times
crying.
because of the defendant's health issues.
Your Honor, I would add that Article 11 states that Ms. Gilbert is to comply with the conditions of Department of Human Health Services. So I believe that her compliance, continued compliance is relevant to this.
Which we're not disagreeing. We fully understand that she needs to comply. But
I'm
she needs to
doing that.
comply in that case too.
Foster worker told me yesterday, I have the text that I'm doing good. She's proud of me and everything.
All right. This isn't so much a punishment or a sentence for what you're doing now. It's a sentence for a crime that was committed. In 2023, and then 2024 wasn't good.
And Kara was back.
All right, you've said enough. We don't just blurt things out.
Okay, sorry.
But the only reason I didn't put you in jail at the time of the proceeding was because you were the primary care parent of the children. You've done some things you were supposed to do, some things you weren't. You are struggling to make your way through life. But this is all visited on your kids. I don't know that they're ever going to be able to undo all the harm that's been done to them. Up to and through your relationship with Dwayne, the way they've been dealt with since this incident was charged. There has been much damage done that's going to be very difficult to undo. And through this probation, I was trying to prevent that. I wanted you to cooperate with CPS, follow all their directives, and it didn't happen.
And I
don't want to hear anymore.
I
You're
know,
going to go
sorry.
to jail for 90 days, credit 8. I'm going to revoke your probation. There's no sense to have you on this probation at this point. You don't have to test for me anymore. You'll be under the supervision of Children's Protective Services. The restitution in the other case is reserved, but it's unlikely we're going to be able to collect that. But probation is revoked.
please. I mean, I just got a job and everything.
Yes, I'm sorry about that.
And I've got her.
There's a consequence, and I had a serious order and you didn't follow it, and you've done very much damage to your children, and I'm embarrassed that we're even in this posture. You'll be out, you'll get good time. There may be medical issues. The sheriff probably doesn't want this, but I told you to comply with the directives of CPS, and the bottom line is you allowed this child to be back in the presence and in the same home with the person that was alleged to. You can go with the officer.
Thank you for watching. If you enjoy watching this content, please like and subscribe. It helps new channels like this one gain exposure. There is a lot more good court to come, so if you like what you saw, tell your friends. If you didn't, tell me and let me know what you'd like to see and how I can improve. Thanks.